Just like Mr. Witty, I underestimated my pace. I type using one finger, like Professor Wajakoya. Of course, we know the background of the matter. I will not set out the background. Through learned counsel, Mr. Witty and Mr. Akula, the state opposed release of the first accused on bond or bail, citing grounds set out in the affidavit sworn on 19th May 2025 by the forensic investigator of EACC, Mr. Robert Rono, which for purposes of this application were clustered into three grounds. First, it was submitted that the first accused is likely to interfere with witnesses. Second, it was submitted that the public safety dictates that the first accused is denied bail or bond. Third, it was submitted that the severity of the offenses justify denial of bail or bond. Through his advocates, led by Mr. Mashari and Jeru, the first accused sought to be released on free bond and or reasonable bail and or bond, arguing that the evidence placed before the court is insufficient to make the cut for compelling reasons. Missions of learned prosecution counsel Mr. Ombati, Mr. Witty, and Mr. Akula, representing the state as captured in the court record, are incorporated into this ruling as if they are set out herein verbatim seriatim. Similarly, dictated by the same reason, the submissions of learned counsel representing the first accused, namely Mr. Mashari and Jeru, Mr. Njiru, Mr. Echesa, Mr. Simiu, Professor Wajakoya, Mr. Ndubi, and Dr. Haminwa, are also captured in the as captured in the court record, are also incorporated into this ruling as if they are set out in the ruling verbatim seriatim. This court has considered the grounds canvassed both in support and in opposition of bond and all bail in respect to the first accused. Gathering from the affidavit in opposition to bail, the response thereto, the respective submissions canvassed by all learned counsel, three questions for determination have commended themselves as follows. First, whether the state has made a case to justify a decision of this court to deny the first accused bond and or bail. Second, whether the evidence which was gathered from the first accused's residence situated in Milimani area within Kitale was unlawfully obtained. And third, whether the constitutional rights of the first accused were violated. I will analyze each question in turn. Relating to the first question, I will summarize. I have discussed the history of bail and bond in Kenya, the Republic of Kenya, both pre-colonial and post-colonial. That led me to the Constitution of Kenya 2010, in particular Article 49, 1H of the Constitution, which is at the center of this application. I also discussed the provisions of sections 123 and 123 capital A of the Criminal Procedure Code. In particular, in actualizing Article 49(1)H, the Statute Law Miscellaneous Amendments Act 2014, number 18 of 2014, dated 24th November 2014, introduced into the Criminal Procedure Code Section 123A, which stipulates as follows: exception to right to bail. Subsection 1, subject to Article 49(1)H of the Constitution, and notwithstanding Section 123, in making a decision on bail and bond, the court shall have regard to all the relevant circumstances, and in particular, A, the nature or seriousness of the offense; B, the character, antecedents, associations, and community ties of the accused person; C, the defendant's record in respect of the fulfillment of obligations under previous grants of bail; and D, the strength of the evidence of his having committed the offense. Subsection 2 provides that a person who is arrested or charged with any offense shall be granted bail unless the court is satisfied that the person, A, has previously been granted bail and has failed to surrender to custody, and that if released on bail, into brackets, whether or not subject to conditions, it is likely that he would fail to surrender to custody. And B, the last condition, should be kept in custody for his own protection. In my mind, therefore, I entertain no doubt that any accused post the 2010 Constitution, notwithstanding the nature of the offense, is entitled to release on bond or bail, save where the DPP adduces facts and evidence constituting compelling reasons. The prominent divergency from the repealed Constitution is that the Constitution of Kenya 2010 now enjoins the court to strike a balance between the rights of the accused and those of the victims. I'm skipping some parts for your own reading. I have cited several decisions in line of that principle of a delicate balance between the competing rights. I've also considered the bail and bond policy guidelines of March 2015 and the construction assigned to how that policy has been construed by the superior courts, and in particular in Republic against Richard David Alden, reported in 2016 in the electronic version of the Kenya Law Reports. So I have also discussed diverse considerations in decisional law and diverse grounds in decisional law, most of which I will not read word after another. I will skip to the standard of proof What then is the standard of proof? And how should compelling reasons be presented? In Java, against the Republic, reported in 1973, East Africa reports at page 39, it was held that in opposing applications for bond, that is the Court of Appeals saying, or bail, on grounds set out herein above, it is not enough for the prosecution to make bare objections and insinuations. It was underlined that the said objections should demonstrate how release of the accused will be detrimental to justice by being supported by cogent reasons and facts. The decision to grant or refuse bail is only based on probabilities and not certainties. The standard of proof, therefore, is on a balance of probabilities, as opposed to the standard applicable in proving criminal charges. Having carefully considered each of the three grounds advanced in support of the objection to bail or bond in the context of the afore discussed statutory considerations and grounds, plus the decisional law considerations and grounds, on a balance of probability, in summary, although palpable fear was apparent, unfortunately the evidence presented failed to generate persuasion in my mind that it is more probable than not that the first accused is likely to interfere with witnesses. I further find the grounds of public safety and severity of the offenses unpersuasive. In any event, gathering from the foregoing principles, the apprehension of the state of interference of witnesses and exhibits can be addressed using alternative means in lieu of the drastic step of denial of bond or bail. Wherefore, this court reaches a conclusion that the state has failed to present compelling reasons to deny the first accused bail or bond. Question B, whether the evidence which was gathered from the first accused's residence situated in Milimani area within Kitale was unlawfully obtained. Concerning this question, intentionally so, this court refrains from determining it at this stage on account of the fact that the nature of the question commends itself for determination by the trial court. Question C, whether the constitutional rights of the first accused were violated. Concerning this question, this court too refrains from determining it now on account of the fact that it was raised informally from the bar, in a manner stripping it of the manner of pleading such questions as enunciated in the Locus Classicus and Arita Carini case, a principle which has since received adoration and affirmation by the Supreme Court of Kenya in a liturgy of cases. Further, this is a question capable of determination in another forum separately. Disposition. Consequently, in regard to bond and bail, this court directs and orders as follows. That pursuant to Article 49, Clause 1, Paragraph H of the Constitution, and Section 123, Capital A, Subsection 1 of the Criminal Procedure Code, the first accused is admitted to both cash bail and bond. B, that the first accused shall be released upon executing a bond of Kenya shillings 1 million with one surety of the same amount. Alternatively, the first accused shall be released upon depositing cash bail in the sum of Kenya shillings 500,000 and providing 2 suitable contact persons whose particulars shall be captured by the registry, including copies of identity cards, their contacts, and other details that may be required by the registry. C, upon release and while at large, and to address the apprehension raised by the state, the following conditions and restrictions shall apply. Roman 1, that the first accused undertakes not to interfere with witnesses and or evidence. Roman 2, in order to allow EACC to secure evidence and witnesses, if any, or if there is further evidence to be secured, the first accused is prevented from going to his office at the county headquarters for a period of 60 days running from today. Roman 3, that the first accused undertakes that he shall neither commit any offense nor interfere with the investigations nor threaten witnesses in relation to this matter. Roman 4, that in the event they are protected witnesses, the first accused undertakes not to flout the law and restrictions which govern protected witnesses. Roman 5, that the first accused undertakes to appear before court as and when required. Roman 6, that the first accused undertakes to arrive in the courtroom at least 15 minutes to the appointed time for mention or hearing unless exempted from attending court physically. Roman 7, that in the exceptional occasions where proceedings are conducted virtually, upon directions of the court, which will issue from time to time, the first accused undertakes to join the virtual platform at least 15 minutes before the appointed time. Roman 8, that in case of bond, the proposed surety shall provide security acceptable to the court upon verification thereof. Roman 9, is joined with 8. It provides the kind of surety that is expected by the court. It's a long provision which can be read by yourselves. Roman 10, that all documents provided by the proposed surety as security in this regard shall be subject to verification by the investigation officer at the cost of the state. Roman 11, that the first accused is not permitted to exit Kenya except with the express permission of the court. And Roman 12, that the first accused is warned against offending the sub judice rule. In this connection, except in the court proceedings to ensue, the first accused is warned against discussing in public, including in or with the media, the merits or otherwise of this case. D, that the first accused is hereby notified and accordingly undertakes that breach of any of the foregoing conditions shall attract consequences as prescribed by law, including but not limited to cancellation of the bond or bail terms, with the attendant consequence of being held in remand, prison, until conclusion of the case. Finally, in compliance with Article 52G of the Constitution, the prosecution is directed to supply all documents upon which the state will place reliance to the defense before the next mentioned dates. In this regard, the prosecution shall be deemed to have complied by doing the following. A, if any, tabulating the full list of prosecution witnesses, briefly indicating the nature of evidence each witness will present, unless the witness is protected, and the approximate time each witness is likely to take in examination in chief. B, if any, preparing a bundle of documents, binding them serially, with the exception of the bundle retained by the Director of Public Prosecutions for purposes of production in evidence, and tabulating the list of documents in the bundle, describing each document, paginating each serially, and indicating the corresponding number of pages for each document. And where only part of the document is relevant, highlighting the relevant part of the document. C, if the number of documents cannot fit one bundle, the prosecution is at liberty to serialize them in volumes. D, the prosecution is directed to serve the said list of witnesses and bound documents upon the accused or the accused's counsel, whichever is applicable, before the next mentioned date. E, the prosecution is further directed to share with the court the following: the tabulated list of witnesses and the tabulated list of documents only. F, all copies of the tabulated list of witnesses and the said band of documents held by all parties shall be identical to the originals held by the state. And very finally, this matter is allocated to court number 4 for further directions, hearing, and determination. In this connection, there will be a mention before court number 4 on 3rd of June 2025 at 9:00 a.m. for pretrial directions.
Governor, it is our plea that whatever visits that are to be made by the EACC, the investigating team, it is only fair for the accused person is also present to avoid the police officers who are already outside the court, and is an indication that there could be an attempt again to the arrest, which this bill has been granted. Consequently, that bill to anticipatory bill to also cover any intended arrest, if at all, will bring oneself.
Tenets of justice. In addition to what our lead team leader has said, I would like you to take into the custody of the office of the governor. The custody of the office of the governor should be secure and to be fair on both sides of the coin. Should you make a decision, we would like you to consider that we have a concurrent custody of the office of the governor, so that we do not leave any doubts that may lead to the fruits of a poisonous tree, if I may make that in reference to the Miranda case of 1967, in that any evidence obtained unlawfully without justification will always be rendered unlawful as having been obtained through the fruits of exaggeration. Thank you.
In relation to the 2 months and the office of the governor, you want to bear in mind that the governor's office is executed by the governor and the CECs. Could you be kind enough to give further directions, Your Honor, so that in the event the governor is needed to execute his constitutional mandate, then probably there will be a way of doing it. That office is his office, and unless it is a branch, Your Honor, then it means for 2 months the governor is not able to work. And that goes against the Constitution, Your Honor, and against the people of this county. I thank you.
Finally, Your Honor, to address the court on the issue of where we find ourselves as a country in terms of budget cycle. We are in the budget cycle that affects both the national government and the county government.
Sorry, Your Honor. Sorry. We need to understand all to notice being issued for the ESC when they go to access for propriety, so that the accused person may be represented by counsel. We are not agreeable, however, to what Professor Wajakoya is calling concurrent custody. I've never heard about that. The office has been characterized, at least from our end, as a scene of crime. Your orders capture the protection for both sides, that if the investigators are to access, the notice will be given so that counsel for the accused person is present to protect his rights. We are afraid, or rather I'm afraid, but I've shared with my colleagues, we cannot give an undertaking. You know, the role of the prosecutor is simply to institute and undertake criminal proceedings. While I do, like I said, I have always had reason to believe Senior Macharia Njeru is a man of his word. But I do not have any basis, or I'm not blessed with the same information he has, that there may be an arrest after this. Secondly, arrests are done by investigative agencies. The ODP does not involve in arrests. So unfortunately, we can't give that undertaking, but we join him in the hope that there's no arrest that happens. However, Your Honor, very importantly, should an arrest ensue on the basis of the same facts where the court has given a bond, then counsel are very aware that they can come back to you and give and seek appropriate orders. I'm not able to go into possible arrest for any other offense, which I'm not aware of. Maybe Senior would have done better to add additional facts. But for his suspicion, we are unable to give an undertaking. We join him in the hope that there will be no arrest. But if the arrest is to happen, they know how to seek subsequent orders from the court, or even from the High Court, if necessary. We are obliged. Thank you.
To protect the integrity of the order that is granted, I've given an statement to state that whenever it's required, both the first accused person and myself. So, with that understanding, protection. So that is not again grabbed outside here.
Because the first request was from Mr. Ombati, it is granted. The second accused, of course, serve the summons latest by tomorrow, 10 a.m. The accused to attend court not later than 22nd of May 2025. Relating to question of visiting the office at ESCC, the request is granted. Court directs that each time ESCC wishes to visit the office of the first accused, they shall be accompanied by counsel on record for the first accused. Concerning the issue raised by the Honorable Manzo, any order issued restricting a right traditionally is construed strictly in the narrow sense it's crafted. So, denying the first accused access to his office for a period of 60 days does not at all stop the first accused from working. The denial to access the office means that the physical office, and that is why it's specified the headquarters for the period of 60 days. That is what it means. So that office, if ESCC after 60 days they're like, we are done, then if there are issues, the court will be approached. If there are not issues, of course, that will be the end of that restriction. I did not wish to give a permanent restriction as yet. However, if other courts in the future think that there is need for permanent restriction, that I'm not in control. What other issue? I think I've learned about that issue enough.
Potential arrest.
For potential arrest, unfortunately, all counsel seated here understand my limitations. Before I understand, they understand. So I think the High Court is just across the road. We can approach it for if there is a problem, but I want to believe we are not acting that way. That is, I'm just expressing a feeling. I don't think we want to act that way. The less I say about that, the better. Allow me to stop there.
Much obliged.
I mean, it's
given a cash bail of 500,000. Shortly, we believe he'll be processed and released to go back home. We know that bail is a constitutional right, and we thank the judiciary for respecting that constitutional right to release Governor Natembeya on bail. But the restrictions given were actually very strenuous, including blocking the governor from going to his office for 60 days. As lawyers of the accused person, we still feel those conditions given were rather strenuous, and we will be consulting whether to appeal or to seek a review of those restrictions, because he's an elected leader, elected by the people of NZOIA to work for them for 5 years. So cutting out 60 days, restricting him, is really, really an onerous condition that has been imposed on him. However, we still go back to what we said, and we continue saying that our criminal justice system has been weaponized. It has been politicized. And when political warfare is taken to the courts, it's no longer political warfare. It is what our lead counsel today, senior counsel Macharia Njeru, called lawfare. What we're witnessing today is lawfare. Politicization of the criminal justice system and weaponization of the criminal justice system to settle political scores. We want to thank the leaders from our coalition who have come out to stand with us today, We have the Honorable Jimmy Wanjigi here, Safina Party. He has been here with us from morning. The Honorable Fred Matiang'i has sent Senator Onyonka here. He has been with us in court. The Honorable Martha Karua is in Uganda, representing Kiza Besigye. But she sent the SG. Asha is here. Asha Bashir is here, representing the People's Liberation Party. We do have the leader of WIPA, Honorable Kalonzo Musyoka. He had a funeral today. He was burying his uncle in Seikuru. But he has sent Senator Manzo, who has been here with us since morning, and WIPA is very well represented. Roots Party, led by the party leader, Professor Ojakoya, who's one of the councils. He has been here with us. We have the DNA Party, Honorable Kanotiti, our Mnyoro pia imetuma representation. This solidarity is what we really want to celebrate. And to look Ruto in the eye and tell him, we will not allow you to weaponize the criminal justice system, to intimidate the opposition, and to think you'll get away with it. Or you think you use the police, use our courts to get a second term. We want to tell you, you are still a one-term president. Let me invite the Honorable Jimmy Wanjigi to say something. Thank you.
I'll be very brief.
But persecution. Try to see us all united against the persecution of one man who has stood up to point a finger in the right direction. It is not a secret in the world. From the North Pole to the South Pole to the entire world, mwizi number one in Kenya anajulikana. He is known. EACC, you should be pointing your guns at that mwizi number one who is known, not at those who are pointing at him and calling him mwizi so that we can all hear. This is pure persecution. You shall not succeed, William Ruto. You shall fail as you failed in everything else. This shows you and shows the world just how desperate you are. You are failing and you continually fail. Asante sana.
Been promised before that police I believe all of us behind the law and apprehend people on Friday to torture them till Monday really is unconstitutional, and I think the police now should know that we are willing to appear all Kenyans wherever we are summoned. No need to apprehend unnecessary. If you call us, we will present ourselves.
At some point, a good leader measures when he is politicking and when he does serious business. Right now, the president wants to start picking people and arresting them. I want to mention to him, you will do it, but you will not succeed. We've been arrested before, we've been put in jail before, we will come to this court again and again. This country deserves better, and we'll make sure Kenya becomes a country that we are proud of. Any personal issues you may have with Natembeya because of the Tawe movement, boss, you also go and set your own Tawe movement somewhere else. Thank you.
On behalf of the People's Liberation Party and on behalf of Martha Karua, mine is just a simple message. This government is do the right thing and serve Kenyans.
Thank you very much. Because I said the professor can conclude for us so that we take a few.
Thank you very much. I would like to thank Honorable Eugene Wamalwa for having called me this morning. I was going somewhere, but then he just told me, put on your pants and move here, and I did. I wouldn't want to say much because I'm fully involved in litigation. Otherwise, I'll be going against the rules. And we shall try our level best. Thank you very much.
Tunasema one time.
One time.
One time.
One time.
One time.
Apende asipende.
One time.
Tawe. One time. Tawe. 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 Tawe.
Nunca se estuvo en esa hora. Tuende wafuate. Acha marudi. One time. Simjamtetea hizo. Oh. Ana wabana kutoka wapi? Tulikuwa Karena kata eish. Bumbili ndo kujitani wote. Asos tu. One down. Nisaidia na nini? One down.
Nilikuwa kwenye Mandoro. Serious. Na huyu babe. Huyo bayo. Valentine.
My lord. Hata nyangoni kutetea lakini amekimbia hivi.
One time.